Good afternoon everyone and welcome to our webinar. Thank you for joining us today. I'm Helen Forrest Hall, Head of Regulatory Communications at the Pensions Regulator, and I'm delighted to be your host for today. We're running this event to support our Defined Benefit Funding Code, which came into force last month. Colleagues will be talking with you about both the new funding regime and the Code of Practice. But before we begin, I thought it might be useful to provide a little context. In May 2016, our then CEO appeared at a Work and Pensions Committee inquiry on BHS, following the company going into administration. The committee asked questions about earlier actuarial valuations and how we'd engage with the scheme trustees. Our work ultimately produced an excellent deal to protect members' benefits, with £360 million of additional funding. This started to shine a spotlight on the funding regime. In February 2018, our CEO returned to the committee to discuss Carillion, an organisation we'd engaged with extensively on valuations of their schemes, but struggled to make the case for faster funding. This was the backdrop to the white paper on DB funding, which was published in March 2018 to review the DB funding system. The paper concluded that while the system was working largely as intended, in some schemes the security of members' benefits was at risk. The paper cited short-term thinking, lack of accountability and transparency over risk-taking, and difficulties in taking effective regulatory action. Following the paper, the government announced a package of measures. These covered avoidance and funding to deal with parties who abuse the system. On the funding side, the aim was for better long-term planning and risk management. The measures also sought a better balance of flexibility for scheme-specific approaches with clear funding standards to support trustees. It's 6.5 years since the white paper was published. The subsequent action has taken longer than anyone expected, but the tumultuous events of the past few years impacted everything, including this project. However, everything is now in place for trustees to follow the new requirements. So what are we going to talk about today? Firstly, Andrew will provide a short overview of the new DB funding package and outline the new parts. Then we'll look at the new funding and investment strategy, or FIS, requirements. Martin will explain what we mean by low dependency by significant maturity and how that differs for open schemes compared to closed ones. Katrina will then go through our guidance in the Code on Employer Confident, something that's been put into legislation for the first time, and particularly the new key periods of reliability and longevity. She'll then explain how that feeds into the scheme's journey planning based on the risk the employer can support. Next, we'll move on to how the FIS applies to scheme valuations. Martin will explain our guidance on setting technical provisions consistently with the FIS. Katrina will then run through trustees' considerations when agreeing recovery plans and demonstrating reasonable affordability of contributions when there are other reasonable alternative uses of the employer's cash. Next, Andrew will explain how we will approach regulation of the scheme's valuations, particularly the twin-track approach of demonstrating compliance via fast track or bespoke. He'll then outline our interim response to the Statement of Strategy and the changes we've made following the consultation. Before we dive in, I'd like to highlight that you'll have the opportunity to ask our expert panel questions during our Q&A at the end. You're also welcome to submit written questions in the box next to this video player. For those who've attended our webinars before, you'll notice a change in our approach. We've streamlined the slides to make them more engaging and easier to follow, allowing you to focus on the discussion. Rest assured, all the information will be available for download during the webinar, including a full set of reference slides, a useful links document, and a recording of today's session will be available in a few days. We very much appreciate your feedback on today's webinar. There's a survey available at the top of the menu on the left-hand side of the video player. Please do fill this out before you leave, even if you're unable to stay with us until the end. And now I will hand over to Andrew to get us started.
Thanks, Helen, and afternoon, everyone. The DB Code is the fruition of 6 years of hard work. We consulted on the code twice and helped DWP ensure legislation was in place to support schemes undertaking evaluation on or after the 22nd of September this year. The engagement that we had across the industry, combined with the many consultation responses we received, helped to get the balance between scheme-specific flexibility and clearer standards in the final code. As a package, the new funding regime builds on its predecessor and best practice to ensure better long-term planning and risk management. It's important to understand how the whole package fits together. Trustees are obliged to comply with the legislation in the Pensions Scheme Act and Funding and Investment Strategy regulations. The code provides the trustees with the tools and guidance they need to comply, clearly setting out our expectations when approaching the funding of DB schemes. So what's different from the previous regime? trustees must now plan for low dependency on their employer by the point of significant maturity, and we will explain what we mean by both of those terms today. Trustees must set a journey plan from their current position to low dependency at a future date, taking risk that is supportable based on the employer covenant and the time they have available. These two aspects form the Funding and Investment Strategy, or FIS, and the scheme's technical provisions must now be set consistently with that strategy. The statutory funding objective, to have sufficient assets to cover your technical provisions, remains. But now, if there is a deficit, the recovery plan must be based on the reasonable affordability of the employer, whilst taking account of the impact on the employer's sustainable growth. The trustees must set out the FIS and other matters in the Statement of Strategy and send it to us. And we'll be seeing that for all actuarial valuations, not just those where there is a deficit. We're going to talk about all of these new aspects during the rest of the webinar. I'm now going to hand over to Martin, who will take you through the new Funding and Investment Strategy requirements.
Thank you, Andrew. Let's begin by looking at the detail of the changes in the new legislative framework that the Code is a part of. Schemes will need to have a long-term funding and investment strategy. As part of this, they must reach something called a position of low dependency, and this needs to be done by a time known as significant maturity. What does low dependency mean? To consider that, we need to think about what low dependency means for both investment and funding. For investment, regulations define an investment strategy called the Low Dependency Investment Allocation, the LDIA. For funding, regulations define an actuarial basis, a set of assumptions to value the liabilities, called the Low Dependency Funding Basis, the LDFB. These assumptions depend on that low dependency investment allocation. To be in a state of low dependency, the scheme needs to be fully funded on the low dependency funding basis. The state of low dependency must broadly happen by the time the scheme reaches significant maturity. To determine this, the scheme must know how to measure the maturity of a scheme, and then once that is done, compare it to a defined point of significant maturity. Let's look at these in more detail. Starting with the LDIA. The legislation says that under this strategy, the value of the assets relative to the value of the scheme's liabilities is highly resilient to short-term adverse changes in market conditions. This means that we would expect assets to move broadly in line with liabilities and vice versa. So, for example, where the liabilities increase because of market movements, then under this investment strategy, we would expect assets to move similarly. In this way, for schemes that are fully funded, a large deficit should not suddenly arise because of market movements, and therefore no further employer contributions may be expected to be required because of the investment strategy. The Code gives more detail of our expectations in this regard and makes clear there is a lot of flexibility in setting this strategy. It is not prescriptive, instead it offers principles for trustees to consider rather than rules. The Code makes clear that the LDIA can include some growth-type assets, like equities or investments in productive finance, as well as matching assets like gilts or bonds. Schemes are not actually required to invest in line with the LDIA, or indeed the funding and investment strategy more widely, although we expect many will do. This is a deliberate move to avoid undermining trustees' existing powers on investments. Where the LDIA is essential is in determining funding at low dependency. At low dependency, a scheme must be fully funded on a low dependency funding basis, which is set with reference to the LDIA, irrespective of what the scheme is actually invested in. The low dependency funding basis is a set of assumptions, both financial and demographic, which is used to value the scheme benefits for each of the members. The legislative requirement is that if the scheme is fully funded on the low dependency funding basis, then no further employer contributions are expected, and the Code makes clear this should be the expectation under reasonably foreseeable circumstances. This expectation of no further employer contributions echoes that in the LDIA and is a key requirement for low dependency. This is only an expectation, and it is possible further contributions might be needed, as the requirement is for low dependency, not no dependency on the employer. As we have said, the scheme must reach a position of low dependency broadly by the time the scheme is significantly mature. To work this out, first we must consider how to measure the maturity of the scheme, and there are different ways of doing this. Maturity can be thought of broadly as how old a scheme is, with older schemes closer to making a final payment to the final member. Under legislation, a measure called duration must be used to measure maturity. Duration is broadly the average time of when all the payments due from the scheme are to be made. This means, perhaps counterintuitively, that the more mature the scheme is, the lower its duration. The solid line in the graph shows how the duration changes over time, with duration getting lower as the scheme becomes more mature. A scheme reaches a point of significant maturity when it reaches a defined duration. The regulations set out that this will be specified in the code. For most schemes, this is when the scheme reaches a duration of 10 years. In the graph, the horizontal dashed line represents a duration of 10 years, and the graph shows when the scheme will reach significant maturity, which in this example is in roughly 20 years' time. So far, we have referred to significant maturity as the key determinant for reaching low dependency. But the key metric is something closely related to this and is known as the relevant date. For schemes who have not reached significant maturity, the relevant date is no later than the end of the scheme year in which the scheme reaches significant maturity. Considering maturity provides an excellent opportunity to discuss open schemes, which are a critical part of the universe of pension schemes. Open schemes have different characteristics to closed schemes, and we have highlighted where this means our expectations are different for open schemes in the code. We have also introduced a new section in the code collating all those expectations for open schemes. One important area where open schemes have different characteristics is in projecting future maturity. Open schemes can allow for new entrants and future accrual. This means it can take longer for those schemes to be expected to reach significant maturity and therefore low dependency. Because of this extra time, it means technical provisions of the scheme used in the valuation can be lower than an equivalent closed scheme. These assumptions used by open schemes for new entrants and future accrual in projecting future maturity can therefore be very important, and we set out our expectations for them in the code. I'm now going to hand over to Katrina to talk through employer covenant and journey planning.
Thank you, Martin. Although the concept of assessing the employer covenant is not new, this is the first time that it has been explicitly recognised in the legislation as a key underpin for supportable risk before the relevant date. Building on the definition of covenant as set out in legislation, the code provides further detail on the two main areas that trustees should consider when assessing their covenant. This includes understanding the financial ability of the employer to support the scheme based on its legal obligations, and any additional support that could be provided to the scheme from existing contingent assets. When assessing the financial ability of the employer to support the scheme, trustees should start by considering the employer's current and future cash flows. Trustees should understand the level of cash that will be available to the scheme to pay any existing deficit through their recovery plan and to remedy any additional deficit that may arise if there were to be a scheme stress event. Furthermore, trustees must form a view on the employer's prospects. This will help determine the extent and duration of reliance that trustees can place on the employer to continue to support the scheme. Factors to consider include the employer's market position and outlook, the strategic importance of the employer within the wider group where applicable, the employer's balance sheet resilience, as well as environmental, social and governance factors, among other things. Once trustees have formed a view on the employer's cash flows and prospects, they can use this assessment to determine the employer's reliability period. This is the period over which trustees can be reasonably certain of the employer's cash flows. The code goes into more detail on how trustees can determine this period and sets out our general expectations that for most schemes, this period will be between 3 to 6 years. We note, however, that the reliability period may be shorter or longer depending on employer circumstances. Trustees should also consider covenant longevity. This is the period in which trustees can be reasonably certain that the employer will be able to continue to support the scheme. We expect this period to be no more than 10 years for most schemes. In addition to looking at the financial ability of the employer to support the scheme, trustees should also consider any contingent asset support provided to the scheme. When assessing contingent asset support, the code is clear that trustees should only rely on contingent assets to support additional risk-taking where they can be reasonably expect that it is legally enforceable and is sufficient to provide the specified level of support when required. This is an area where we are keen to improve general market practice, and we will provide further guidance on how to quantify the value of a contingent asset in the updated covenant guidance. Although the code touches on various types of contingent assets, it also introduces the concept of a look-through guarantee, which effectively replicates the obligations of the employer onto the guarantor. Where a guarantee is structured in such a way, the trustees are able to assess the guarantor as if it were an employer of the scheme, and therefore can factor the guarantor into their assessment of cash and prospects. Although we expect all schemes to undergo a covenant assessment, at least at each scheme valuation, we recognise the importance of taking a proportionate approach. In fact, proportionality is a key theme that flows throughout the whole code. As set out in the DB Funding Code, we expect more work to be done where a scheme is running higher risk or has a low funding level, whereas a lighter touch assessment may be more appropriate where the scheme is well funded, running limited risk, or is small relative to the level of available covenant support. Finally, consistent with previous messaging, TPR is continuing to move away from more subjective covenant ratings. Instead, we will be focusing on whether a scheme's covenant, being cash and contingent asset support, is sufficient to support the level of risk being taken by the scheme. So now we've talked about how we expect trustees to assess their employee covenant. The next few slides will go into more detail about how trustees should use the outcome of this assessment to ensure that the scheme is meeting the supportability principle. This principle requires trustees to set the level of funding risk assumed within the scheme's journey plan to low dependency in line with the trustee's assessment of employee covenant, and subject to that, the maturity of the scheme. This chart shows what a journey plan could look like for a typical scheme that has not yet reached significant maturity or full funding on a low dependency basis. The line shows how the scheme's technical provision liabilities are expected to move over time so that by the time the scheme reaches significant maturity, its liabilities will be in line with its low dependency target. For most schemes, we expect in the period up to low dependency, there will be an inherent level of funding and investment risk that can be baked into the scheme's journey plan that should be based on the circumstances of the employer and the scheme. It is this level of risk that we are saying must be supportable by the covenant and, subject to that, the maturity of the scheme. Once at low dependency, we expect schemes to be running a prudent level of risk in line with the low dependency investment allocation, and therefore they should have limited reliance on the employer covenant thereafter. The code sets out the principles for how trustees should assess what is an appropriate level of risk to factor into the scheme's journey plan, based on the period in which that risk is being run. Where risk is being run within the reliability period, trustees are expected to undergo an assessment or a test to determine whether the scheme has access to sufficient cash flows or maximum affordable contributions as defined in the code, and contingent asset support over the reliability period to recover both the existing deficit, if any, and any further deficit that could arise from a scheme-related stress event during this period. To help trustees, the code sets out the general principles of what should be considered when performing such a test, whilst also allowing trustees the flexibility to take account of scheme and employer specifics. After the reliability period and up to the relevant date, given there will be less certainty over the level of covenant support available to the scheme during this time, there is a general expectation that trustees should start to consider how to transition or de-risk to meet their low dependency target by the relevant date. Given this, the code shifts from requiring trustees to undergo a more quantitative assessment of supportable risk to instead setting out the principles to consider when assessing if the level of risk being run and the time and the pace in which the scheme is expected to de-risk to low dependency by the relevant date is appropriate. Considerations include understanding the longevity of the covenant and whether any concerns over this should accelerate the de-risking process. Trustees should also consider the level of risk that the scheme is taking during the reliability period relative to the level of available covenant support. Where trustees are running the maximum level of risk during this period, for most schemes, we would expect this level of risk to start reducing from the end of the reliability period. However, where the level of risk is lower relative to what the employer can support, a scheme may wish to run this lower level of risk for longer. Finally, trustees should consider the availability of contingent assets to support the scheme post the reliability period and the maturity of the scheme. This graph sets out an example of how a scheme may decide to de-risk its investment strategy, which is represented by the solid line, over the period to the relevant date. As you will see, post-significant maturity, we would expect the scheme's investment strategy to be in line with the scheme's low dependency investment allocation, which is illustrated by the dashed line. In this example, the scheme is running a relatively high level of supportable risk in the period up to the end of the reliability period, as shown by the top arrow. And therefore, the trustees have decided to take a linear de-risking approach after the reliability period. It's important to note that the Code does not dictate how schemes should de-risk, only that trustees should be able to justify that the level of risk being run throughout the journey plan is supportable. I'll now hand over to Martin to talk through how the issues we've been discussing apply to actuarial valuations.
Thanks, Katrina. And to do that, we will look at the changes in two areas of the actuarial valuation: technical provisions and recovery plans. We start with technical provisions. There is an important new requirement for technical provisions, and that is that they should be consistent with the scheme's funding and investment strategy. We set out our expectation for what this means in the Code. That is that after relevant date, we expect the assumptions are the same or stronger than the low dependency funding basis. And before relevant date, the assumption should be consistent with both the journey plan up to the relevant date and being the same or stronger than the LDFB after this. We do not provide any prescription in the Code for assumptions to be used in the technical provisions, but do provide some guidance and refer to the expectations we have given for some of the LDFB assumptions as also being useful when setting the assumptions for technical provisions. In this section of the Code, we set out our expectations regarding the cost of future accrual. We do this noting that future accrual will become technical provisions in the future. Therefore, we set out our expectation that trustees be mindful of the future accrual in determining their approach to funding and investment. For example, we expect them to include future service when considering what risk is supportable by the employer. I'll now hand you back over to Katrina to talk through recovery plans.
Thanks, Martin. In line with the previous funding regime, where there is a technical provisions deficit at the valuation date, a recovery plan needs to be put in place. However, under the new DB funding regime, trustees must now follow the overriding principle that steps must be taken to recover deficits as soon as the employer can reasonably afford. We expect trustees to assess future reasonable affordability at least on a year-by-year basis, with the structure of the recovery plan set in accordance with this assessment. Trustees are also required to consider the impact of a recovery plan on the sustainable growth of the employer. When determining if a recovery plan is appropriate, trustees should consider the employer's reasonable affordability, which I'll focus on today, whether to allow for post-valuation experience, and whether to allow for investment outperformance. The DB Funding Code sets out three considerations that trustees should take account of when determining an employer's reasonable affordability. The first is understanding the employer's available cash. This comprises employer cash flows and liquid assets after reasonable working capital requirements. Trustees must also take account of the employer's reliability period, which for most schemes will be between 3 to 6 years. Understanding the reliability period is important in determining the reasonableness of alternative uses of cash. However, it does not determine compliance with the legislation. For example, if a scheme's reliability period is 6 years, but the employer can comfortably afford to pay off any technical provision within 3 years, after allowing for sustainable growth and other alternative uses of cash, the recovery plan must be 3 years to comply with the legislation. Finally, trustees will need to determine how much available cash should go to the scheme and how much should reasonably go towards other alternative uses of cash, based on the circumstances of the scheme and the employer. The Code sets out 4 common alternative uses of cash: investment in sustainable growth, covenant leakage, including shareholder payments, discretionary payments to other creditors, such as early debt repayments, and payments to other DB schemes. That said, we acknowledge that there may be other alternative uses of cash, and where these are identified, we expect trustees to evidence why these are reasonable based on the reasonable affordability principles set out within the Code. So what are these reasonable affordability principles? The first principle focuses on sustainable growth and therefore links back to the legislative requirement for trustees to consider the impact of a scheme's recovery plan on the sustainable growth of the employer. Given the importance of providing employers with the flexibility to invest in sustainable growth, the Code makes clear that such investment should be reasonable where the benefits are reasonably certain. Where this benefit is unclear and investment in sustainable growth leads to a recovery plan that exceeds the reliability period, trustees should seek a suitable contingent asset to support the additional risk being run after the reliability period. The second principle ties back to the funding needs of the scheme and the level of funding risk that is factored into the scheme's journey plan. Where a scheme has a lower funding level or is running a higher level of funding risk, it is less reasonable for cash to leave the employer by way of covenant leakage or discretionary payments. The third principle focuses on the reliability of the employer's cash flows, with covenant leakage and discretionary payments being less reasonable if this leads to a recovery plan that exceeds the reliability period, unless a suitable contingent asset is put in place. Trustees must also consider the maturity of the scheme. The more mature the scheme, the greater the need for cash to come into the scheme, and therefore alternative uses of cash will be less reasonable. Finally, trustees should ensure that the allocation of available cash between other DB schemes sponsored by the employers is fair and equitable. These principles are consistent with TPR's previous messaging set out in publications such as the Annual Funding Statement, and therefore should come as no surprise to trustees. However, by elevating these to the new Code, we are looking to drive a more consistent approach across schemes. I'll now pass you over to Andrew, who's going to run through our regulatory approach and the statement of strategy.
Thanks, Katrina. As Helen mentioned earlier, there is a twin-track approach for schemes to demonstrate compliance, fast-track or bespoke. It's worth looking at these in a bit more detail now. Firstly, let's look at fast-track. We are using fast-track as a filter for assessment of a scheme's valuation. It represents our view of tolerated risks where we are unlikely to engage with schemes on their valuations. Schemes can use fast track if they meet a series of parameters on different aspects of the funding strategy, the technical provisions, the risk in the notional investment strategy in the FIS, and the recovery plan. Our fast track parameters and guidance were published last month and is available on our website. If the scheme meets those parameters, then the trustees are unlikely to hear from us. If taking the fast track route, trustees can provide less evidence and explanation in the statement of strategy. It's important to remember that fast track is not risk-free, and meeting fast track does not necessarily mean you have complied. Trustees need to satisfy themselves that their strategy is in line with the legislation and our Code principles. In respect of bespoke, this allows flexibility for scheme-specific approaches based on the principles within the legislation and our Code. Trustees will need to provide more evidence that the risk they are taking is supportable and long-term strategy is appropriate. And we will look at that evidence on their statement of strategy and may engage further to understand the approach. Our focus will be on schemes that take the bespoke route, particularly those schemes which appear to be taking a lot more risk. We expect to engage with a similar number of schemes on their valuations as we do now, and we will be taking a risk-based and outcome-focused approach to assessing the schemes with which to engage. As schemes do their first valuations under the new regime and submit their statements to us, we will build up a bank of data. We will use that data to identify emerging risks across individual schemes and the pensions landscape and respond in a targeted, proportionate way. We consulted on the statement of strategy, and our formal response to the consultation will be coming early next year, but illustrative templates and data lists were published in September and so available for people to use now. A brand new digital service to submit the statement of strategy and valuation documents is expected to be launched in the spring of 2025. Let's look in a bit more detail at the statement itself. There are two parts to it. Part 1, the funding and investment strategy, which must normally be agreed with the employer and includes information we've already been talking about today as shown on the slide. Part 2, the supplementary matters, which the employer must only be consulted on. It's in this second part of the statement where much of the detail of the valuation sits. This includes a summary of the valuation and any recovery plan, and details on covenant and investment risk. It's this part where the amount of information we need to see varies depending on the circumstances of the scheme. We've taken a proportionate approach to the amount of information we require from different schemes, reflecting the feedback we had to our consultation. There are 4 different templates depending on whether you are fast track or bespoke, and pre or post relevant date. We require less information for fast-track schemes and those post-relevant date, particularly on the employer covenant. There are some easements for small schemes with 200 members or less, for example, the discount rate and cash flow information they need to provide. The requirements are also less for schemes which are well funded on a low dependency funding basis. We know that all of these together represents quite a change for some of you, but we hope the guidance in the code will make the work easier and more manageable. It's taken a while to get to this point, and we really appreciate the time and effort you have made to work with us throughout the development of our code and guidance. We will continue to work with you to ensure our guidance is useful and practical. And finally, the big reveal, the covenant guidance will be published tomorrow. I'd now like to hand over to Helen, who will be chairing the Q&A session for us today.
Thanks, Andrew. We'll now give you a couple of minutes to submit your questions. I can see we've got a lot of questions to get through, but before we get started, I would like to introduce Alison Winstanley, one of the pension lawyers at TPR, who's going to be joining us for our Q&A session. So let's kick off with the first question. We've got a question from John, which I'm going to put to Martin. Fast track document for recovery plans. Is the maximum permissible annual increase to DRCs 3% or CPI inflation?
Thanks, Helen. Well, this is an example actually where we've amended our fast track approach following the consultation and following feedback to that consultation to make it more flexible. So we recognise that many schemes don't have set patterns for their deficit repair contributions in the recovery plans. They don't have equal annual increases. So now the recovery plan can allow for different patterns of increases because the test is against the cumulative increase. And the scheme can choose either 3% increases or CPI inflation increases to test against that cumulative test. And the idea of that is to make the fast track even more flexible so that different schemes can use it.
Fabulous. Thanks, Martin. Katrina, on covenant, is there a formal requirement to take external covenant advice under the code, or can a well-informed trustee board still form the covenant review themselves?
Yeah, absolutely. So I think the short answer to that is no, there is no formal requirement under the code to take external covenant advice. And we have actually updated our covenant guidance to provide a lot of detail to enable trustees to do an assessment of covenant themselves. However, we recognise there will be circumstances where it is appropriate to take covenant advice. Examples of that may be where the trustees feel that they don't have the sufficient experience or skill set to be able to do that covenant assessment. They may have concerns around independence or objectivity. And equally, it may be more appropriate to take covenant advice where you've got a very complex scheme or where you're placing a lot of reliance on that covenant. I think what's important as well to recognise here is that you don't necessarily always have to take covenant advice on your whole covenant assessment. Trustees may decide that they're comfortable doing certain sections of it, however they may want to get covenant advice on areas that are more complex.
Fabulous, thank you. Alison, I can come to you next. A question from Simon. You have said that the digital system for submission of the statement of strategy will be ready in the spring of 2025, but obviously the new regime already applies. What happens if evaluation is completed before the new system is launched, triggering the requirement to submit the statement of strategy?
Okay, well, obviously the key thing about this question is what was the effective date of the actuarial valuation? Because if the effective date of the actuarial valuation was before the 22nd of September this year, then you don't have to do a statement of strategy. The existing systems apply and you just submit the pre-existing documentation to TPR on our existing systems as usual. So the problem's only actually going to arise where you have the effective date of your valuation on or after the 22nd of September this year. Now, given that you've got 15 months to actually do your valuation, we're reasonably confident that this isn't going to affect a large number of schemes. But if you do actually have a scheme where you do, for whatever reason, very efficiently get your valuation done before our new system is up and running in the spring of next year, then what we're asking is that trustees actually hold off submitting the statement of strategy to us until the new system is up and running. We're comfortable that that really shouldn't cause a problem because it doesn't actually prevent you from completing your valuation or statement of strategy. It's just the submission. You've got the templates and everything to work from. And when it comes to the actual legal obligations, the obligation is to submit the statement of strategy as soon as reasonably practicable. And obviously we at TPR determined that this is going to be a digital submission and it's not going to be practicable to do that until our new system is up and running.
Fabulous, thanks Alison. So now we're moving to a video question.
Good afternoon, everyone. My name is Gareth Connolly and I'm a scheme actuary from WTW. My question for the pensions regulator is in relation to the new regime, in that it was drawn up in a time that's quite different from today. So I'm particularly interested in how they think the Mansion House proposals, as they relate to sharing of surplus from ongoing schemes, how they will affect the regulation of the new regime. Thank you.
So Andrew, can I ask you to take this one?
Yeah, sure. So Gareth is absolutely right that the market looks very different now to when we first started working on the code. Back then, around 80% of schemes were in deficit, and now 80% or more of schemes have a TP surplus. And many of those schemes have full funding on a buyout basis or close to full funding. So what the code does is provide a framework for schemes when they're thinking about their end games and what they plan to do, whether that's to run on, to buy out or enter a consolidator. And the code sets out how much risk that schemes can support through the different cycles in its life, including during this endgame state. On the sharing of surplus point, so we think low dependency provides a framework for some of the thinking that's going on as part of the government's pension review about how surplus might be shared in the future and how the rules might be changed, and also will be used by us if and when we regulate the sharing of surplus between members and employers.
Fabulous. Thanks, Andrew. So our next question is from Abby, and I'm going to throw this over to Martin in a second. Please, can we have further information on the treatment of surplus, very topical, when applying the bespoke stress tests? Do we start from full funding or the surplus position, i.e. do we apply the stresses to 100% or 110% funding?
Thanks, Helen. We set out our expectations in the code for the stress tests that the scheme might have to do. There are actually two, and that depends on whether you're before or after relevant date. If you're after relevant date and you're looking at the appropriateness of the low dependency investment allocation, the stress test actually assumes full funding, so you don't allow for a deficit or a surplus. Before relevant date, when you're looking at when you're scheme on the journey plan and you're looking at what risk can be supportable from the employer, you will do a stress test, and there you can allow for the funding of the scheme. Indeed, you probably should. And if you have a surplus, you'll find that you can allow for more risk in your journey plan. So it's a useful thing to allow for.
Fabulous. Thanks, Martin. Right, now a question for Katrina. With reference to paragraph 42 around look-through guarantees, there is a potential for differences of interpretation. Can you confirm that a look-through guarantee does not need to explicitly state that the trustee can review affordability based on the resources of the guarantor? Alternatively, if a guarantee covers all current and future liabilities and or states that access to the guarantor should be as if it were the statutory employer, is that enough to meet the definition of a look-through guarantee? And secondly, would simply guaranteeing contribution schedules and Section 75 liability not amount to a look-through guarantee?
Yeah, absolutely. So first, it's important to note that we will be providing a lot more information around look-through guarantees in the upcoming covenant guidance that's out tomorrow. In particular, we'll be setting out the criteria that a guarantee needs to meet the definition of a look-through guarantee. And we'll also be confirming that when documenting this criteria, it can be done through separate legally binding agreements or a side letter. It doesn't necessarily require trustees to amend the existing guarantee document itself. In terms of legal terminology per se, we aren't prescriptive about what legal terminology needs to go into the actual legal framework of the guarantee. Instead, what we do require trustees to do is to seek covenant advice, legal advice, to make sure that the guarantee is drafted in such a way that it does allow this legal look through to affordability to the guarantor and also fulfills the other requirements under the look through definition. Taking the last example, so when you haven't got a guarantee that has this formal look through to affordability, so for example, where you might have a guarantee that covers missed deficit repair contributions or provides a Section 75 underpin, the difficulty with that is actually the trustees and the pension regulator don't have the power to go to the guarantor and look at its affordability when setting a recovery plan. Given that, it wouldn't meet our criteria of a look-through guarantee. It is important to note, however, that doesn't mean it doesn't have any value at all. In fact, the guidance will go into a little bit more detail about how trustees can potentially place value on these non-look-through guarantees. It also shouldn't detract from some of those other benefits that you get from guarantees. For example, it enables you to have a seat at the table during negotiations. It could also help contribute to or strengthen the prospects of the employer as well.
Fabulous, thank you. Next question from Eloise. I'm going to throw over to Alison. As the code is not law, what do we as TPR propose to do where there is non-compliance?
Well, I think the first thing to say is that if you had trouble complying and you just weren't sure how to comply or you need guidance, we'd very much encourage you to get in touch with us. We're all about actually ensuring compliance, not about giving penalties for the sake of it, so to speak. If, however, we have a situation where you've got deliberate non-compliance and somebody is not asking for help, shall we just say, I think we would regard that as a bit of a warning sign. We wouldn't be very happy about it, and we would certainly be coming to ask questions. And in our experience, if you've got non-compliance with the code, that often means that there are underlying issues which we will potentially need to look into and do something about. It's also important to remember that even if the code isn't law, it can be taken account of in legal proceedings. It does have potential evidential weight. A judge can take account of it. We can also refer to a code in framing an improvement notice. And in relation to the this particular code, the DB funding code, there is a cross-reference to it in the legislation when it comes to the calculation of significant maturity. So you do actually very much need to refer to the code in order to ensure you're complying with the law in that respect.
Fabulous. Thank you, Alison. So the next question is for Andrew, and on the subject of significant maturity. If you are at significant maturity at the inception of the code, the expectation under the fast track approach is to resolve any deficit within 3 years of your next valuation date. Is that correct?
Yes, that is correct. And the reason that there's a different rule for schemes that have gone past significant maturity, and it's 3 years rather than 6, is that when you've reached that stage in the scheme's life cycle, you've got less time to, left to pay out members' benefits, so you need to ensure that the scheme is properly funded.
Fabulous. Thank you. Right, next question is for Martin, and around DB underpin schemes. So members have control over the investment strategy over the majority of the assets. Would this be a sufficient reason to move to a bespoke approach?
Well, I think this is an excellent example of something we talked about earlier, which is that schemes don't actually have to invest in line with their funding and investment strategy. Their actual investments can differ. And this is a really good example of why that might be, because as the questioner says, members have control of the assets. So the funding and investment strategy, the investment strategy there might be quite different. And that's actually the strategy that can be used and should be used in the fast track test. So on its own, there's no reason that a scheme like this should have to go down bespoke. Now, it might well need to, because it needs to go down bespoke, but it doesn't require to go down bespoke.
Fabulous, thank you. So we're now going to move to another video question from Dickon.
My name's Dickon Best. I'm a professional trustee at the Independent Governance Group. Whilst the updated covenant guidance is being launched, contain helpful guidance in relation to how trustees should think about covenant in the context of the new funding code, there will be some new defined terms that will require specific answers to be provided as part of the new statement of strategy, i.e. reliability period and maximum affordable contributions. Trustees don't like making rash statements, but equally these concepts might be subjective. So in reality, what do you think the burden of proof is for trustees?
So Katrina, can I ask you to take this one?
Yeah, absolutely. So I think it's firstly important to say that we do recognise that some of these new concepts, such as reliability, longevity, maximum affordable contributions, are subjective and do require professional judgment when assessing them. Given that, we have introduced kind of some new chapters within the covenant guidance that will address these areas in particular. And we'll also be providing really clear guidance around proportionality when you're assessing these periods, and also some worked examples to help you around that. Ultimately, the level of evidence that you are required to do, or the amount of analysis that you are required to do, will be very much dependent on the level of reliance that you are placing on that concept when you're setting the scheme strategy. So for example, if you are relying on a long reliability period to take a lot of additional risk, then yes, we would be expecting more evidence in that situation than someone that might be taking lower level of risk as a consequence. I don't know, Alison, if you want to add anything to that from a legal perspective.
Essentially, I'm in agreement with what you've said there. I'm not 100% convinced that burden of proof is quite the right term here, but I think we do have to recognise that trustees do need to make judgment calls. They do have to make subjective judgments, and when they're making those decisions, we would expect them to have a justification and have a logic behind the decision that they're making. In that regard, I don't think that it's a particularly high ask of trustees that they should be able to explain the approach that they're taking in the statement of strategy. And certainly the general regulatory approach we're adopting, as you touched on, is to be a risk-based regulator. So certainly if you're making a decision which does involve in taking a greater level of risk, then we would be interested to see more detail in the statement of strategy, and that is something to bear in mind.
Fabulous. Thank you both. Next question from James. I'm going to ask Martin to take this one. So on expenses, does the regulator have an example of what they would expect the expense reserve to be in the load dependency funding basis? How would this be calculated? What a typical expense reserve may be? Noting this introduces commercial sensitivity into the valuations.
Well, I think it will be very different for different schemes. It will vary depending on the size of the scheme, their maturity, what their long-term objective is. So I think it's very difficult to say what a typical one is, and that's why we'd expect the trustees and the scheme to use its judgment in calculating this. We do have an example in Fast Track, and that might be appropriate for some schemes, but it might not.
Fabulous. Thanks, Martin. So next question from Phil. Given the time it took for the new regime to be developed and implemented, is TPR concerned about how quickly it can respond to the changing circumstances of schemes in practice? I'll throw it over to you, Alison, in the first instance.
Well, actually, this is something that we had very much in mind, particularly when we were developing our approach to the statement of strategy. It's very important to TPR that this regime remains appropriate, and therefore we needed to build flexibility into the system. And that is one of the key reasons why, when it comes to the statement of strategy in particular, we actually made the code very much principles based. So that has the high level principles and the detail went into the template. And the advantage of that is that it's a lot easier to amend the template than it is the code, because the code has to go past Parliament. So therefore, by putting it into the template, we've built flexibility into the system so that if things do change going forward and some of the information we're asking for turns out not to be relevant, or things have moved so that it's no longer something that we need to know, we can actually amend that template and take it out, because the last thing that we're interested in is putting, unnecessary burden on schemes and asking questions that are no longer appropriate in a changing pensions world.
Sorry, thanks, Alison. Andrew, is there anything you wanted to add to that?
Yeah, just thinking about our future regulation, the ability to be flexible in terms of what we ask for will enable us to evolve as the market continues to evolve and be regulate in a targeted and proportionate way.
Fabulous. Thank you both. Okay, next question for Katrina. What is your view on how the employer covenant should be assessed in a multi-employer scheme, say one with hundreds of employers?
Absolutely. So the code touches on this, and again, we'll go into more detail in the guidance itself. But I think with multi-employer schemes, we appreciate that it's not always proportionate or appropriate to be looking or doing a full covenant assessment of each of your employers, particularly when you've got hundreds of employers to be able to do that. So what we try to do within the guidance is set out some examples of alternative approaches that trustees of multi-employer schemes may wish to do. So, for example, you may wish to kind of group your employers into subcategories and vary the level of detail based on those subcategories. Otherwise, you might decide that actually it's more appropriate to do a more detailed assessment of those employers with the largest liabilities. The key is that we're not being prescriptive about the approach that you take here, because it is ultimately up to the trustees to decide what is appropriate for their scheme. We also try within the covenant guidance itself to actually, in each of the different chapters that we go through, we do try and bring in specific guidance for multi-employer schemes and named schemes, and also charities and so forth, that provides a little bit more help for those sort of trustees to be able to understand our expectations on them.
Fabulous, thank you. Next question from Claire for Andrew. If the scheme has made a full buy-in, how much attention needs to be paid to employer covenant?
Yeah, so if a scheme has a full buy-in, there's very limited reliance on the covenant because the members' benefits are largely secure. I mean, there could be a true-up payment perhaps when the scheme buys out, but that's not likely to be large. So given the very limited reliance on the covenant, we'd only need to be a limited assessment of the covenant. And actually, we're also asking for less information in the statement of strategy for schemes that's reached this position where they've brought in the benefits.
Fabulous, thank you. Next question for Martin. In calculating a scheme's duration under the LDFB, should the cash flows include projected expenses, or should the duration calculation only be determined on the benefit payments?
This is not actually an area we've been prescriptive on, so we'll leave it for the trustees to get comfortable. We would ask that they are consistent between valuations, and we would note that for many schemes, depending on how they express their expenses, it may not make a difference to the answer anyway.
Fabulous, thank you. Next question. When you say that you expect trustees to assess reasonable affordability on a year-by-year basis, do you mean that you expect them to bring the employer back to the table every year, or to assess year by year when negotiating the recovery plan based on cash flow projections or something else? Andrew, can I bring this to you?
Yeah, happy to take this one. So we don't expect trustees to bring the employer back to the table year by year. We expect them at each valuation to look at the forecast cash flows over a 3-year period or longer and set the recovery plan based on reasonable affordability of those cash flows.
Fabulous, wonderful. Now, another one for you, Martin. The reliability period should reset over time rather than expire. New financial data will become available from the sponsor.
Yeah, absolutely. At every valuation, the reliability period can be assessed again, and if nothing's changed, it will, if it remains the same, but it will actually last for longer into the future as it goes, as time goes on. And so, actually, schemes may find that they can continue to take risk right up until the point of their relevant date. So, absolutely, schemes should be looking again and can revise their funding and investment strategy as they wish based on that new information.
Fabulous. Okay. One for Andrew from John. Are you expecting most schemes to be in fast track?
Yeah, this is the
is
$100
on
million
Yep.
question. So we don't know because, of course, we haven't had any submissions. But what we do know is that we think around 3/4 of schemes, possibly more, could go down the fast track route if they wanted to, without any material change in their strategy they're doing at the moment. So we will wait and see. But I think we would expect most schemes to go down fast track, but we don't know exactly how many.
Fabulous, thank you. A question for Martin to start with. What can TPR offer to help trustees enforce companies to comply with trustees' contribution requests, whether as a refusal of a company to pay even if they can afford to?
Well, we know that it's going to be a joint process where trustees and companies negotiate. The new regulations, and in particular the changes to the recovery plan, actually strengthen the power of the trustees in this regard, because it makes clear that the recovery plan should be set so that the deficit is paid off as soon as is reasonably affordable by the employer. So that strengthens the trustees' hand. Obviously, we expect that in most cases the trustees and company will be able to agree the valuation between them, but there are times when we might need to engage.
Fabulous. Alison, do you want to come in from the legal perspective?
Yes, I mean, in terms of a refusal to pay, I think it's also worth just mentioning that if contributions are unpaid, they are a debt due to the scheme. So that is something that trustees should bear in mind. They're not entirely powerless in this respect. The other factor to remember is that if it's auto-enrolment, that obviously, again, is a statutory regime. So there are a number of legal obligations there that can be enforced.
Fabulous, thank you both. So the next question is for Andrew. Will the statement of strategies need to be updated as PDFs like the current SOC, recovery plan, etc., or will it be more like the current scheme return submission, like an online form?
Well, no, it is going to be an online submission, and actually we've done some user research, engaged with the industry, and we are going to have submissions via Excel. So yeah, very exciting, particularly. So we are. So when we do start submissions, actually, it will be quite a different process to what it's been previously when we've had valuation submissions in the past.
Fabulous. Look out for that. The levels of excitement are palpable. Next one. If the maximum covenant longevity will usually be 10 years, can the journey plan period be more than 10 years? If yes, under what circumstances would this be appropriate? Katrina, could I come to you in the first instance?
Yeah, absolutely. I think the importance here is, so the answer is yes, the journey plan can be longer than that, because ultimately longevity, when feeding into your journey plan, the only time that we say that you need to change your journey plan would be whether you have serious concerns about that longevity. So if you have, for example, a finite period of time in which you know the employer is going to be in existence, then yes, our expectation is that you would be at the end of your journey plan by that point in time. In fact, you would ideally want to be at the end of your end game situation. However, where we say in a lot of circumstances, people will be simply restricted by the fact they can't look beyond that point. So in that situation, provided you don't have underlying concerns, we would expect your journey plan to extend beyond that period.
Fabulous, thank you. There's been a lot to get through and we are on our final question, I'm afraid, but and it's for Katrina again. Very excited to hear about the covenant guidance being published tomorrow. What can we expect from it?
Yeah, absolutely. So this is ultimately the final piece of the puzzle of all the documents that we have promised industry that will help trustees in assessing evaluation under the new DB funding code. So what the guidance itself is looking to do is to update existing covenant guidance that was done, I think it was back in 2014, so a lot of updates needs to be done, but also to align it with the new DB funding code. What we have also tried to do is, as you'll be aware, people provided some really valuable input into the code consultation around covenant, and some areas we weren't able to address specifically in the code, so we've tried to pick that up within the covenant guidance itself. We also, as I've already mentioned, provide a lot more detail around those more subjective or even just the new areas to covenant, such as reliability, longevity, maximum affordable contributions. And we'll also bring a lot of examples in there to try and bring this to life. I think the only other point to raise, which I do say all the time, is just around proportionality. So again, that is a big theme within the guidance itself. So we set out the key factors you need to consider around proportionality in the introduction. But again, it is something that we address as you go through the guidance.
Fabulous. Thank you so much. And thank you to you all for joining today's session and for submitting your questions. We hope you found it valuable. As mentioned earlier, a set of reference slides is now available to download, along with our useful links document, and a replay of this webinar recording will be accessible in a few days' time by navigating back to this page. We'd appreciate your feedback, as I said earlier, so please complete the survey and have your say. As a reminder, you can find this in the menu to the left. Goodbye from all of us, and thank you again.